This is Rianne and Helena doing the Obergefell versus Hodge case.
Our case is about the right to same-sex marriage, which is protected by the Equal Protection Clause and Due Process Clause of the 14th Amendment. It also ties into the Civil Rights Act.
In Michigan, Kentucky, Ohio, and Tennessee, same-sex marriages were not performed, and the states did not recognize same-sex marriages if they were lawfully done in another state. This is because after the court's decision in Windsor rejected the federal government's right to deny same-sex marriages, lower courts divided on the issue of whether the states were also required to recognize such marriages. Many lower courts interpreted Windsor as requiring the states to recognize such marriages on the ground that same-sex marriage is a fundamental right. Other courts ruled that there is no such fundamental right, and the definition of marriage was left to the states themselves. Michigan, Kentucky, Ohio, and Tennessee decided to define marriage as a union between one man and a woman. This is why the petitioners decided to file suits in their home states. One of the petitioners was Obergefell. They claimed that the state officials violated the 14th Amendment by denying them the right to marry or have marriages lawfully performed in another state given full legal recognition.
Obergefell's argument was that the state's denial to recognize same-sex marriages violated the Due Process Clause and Equal Protection Clause because they felt like they should have the same rights when it comes to marriage as opposite-sex couples. This caused them to sue their state agencies.
The states argued that the Constitution does not address same-sex marriage, and therefore it is beyond the purview of the court to decide whether states have to recognize or such license these unions. The states said that this issue should instead be decided by individual state legislatures based on the will of their electorates. In a 5-4 ruling, the Supreme Court ruled that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. This ruling requires all 50 states to perform and recognize the marriages of same-sex couples on the same terms and conditions as the marriages of opposite-sex couples. Chief Justice John Roberts wrote a dissenting opinion, which was joined by Justice Scalia and Thomas. He argued that while same-sex marriage might be fair and good policy, the Constitution doesn't address it, so it should be up to the states where they want to recognize or perform same-sex marriages. Obergefell versus Hodge will allow people who wish to have a same-sex marriage to do so in all states, and the states have to recognize that same-sex couples are married. The supporters of this decision went to social media, public rallies, and pride parades to celebrate the ruling. Some view the Supreme Court's ruling in Obergefell versus Hodge as a serious setback for Americans who believe in the Constitution, the rule of law, self-government, and the marriage as the union of a husband and a wife. 9 counties in Alabama and Texas still do not issue marriage licenses to same-sex couples, even though the ruling dictates that they have to. One other court case that has used the Obergefell versus Hodge argument is Pavon versus Smith. In this case, the Supreme Court reaffirmed Obergefell and ruled that states may not treat married same-sex couples differently from married opposite-sex couples in issuing birth certificates. Overall, the ruling of this court case has received a lot of support, and it has changed the lives of same-sex couples throughout America.